Morning, my name is Michael Einbinder, and I'm from Einbinder & Dunn. We're a law firm in New York City, practicing substantially in the franchise field, representing both franchisors and franchisees. Franchising is a very big business in this country, representing about 15,000 to 20,000 franchisors who have hundreds of thousands of franchisees throughout the country in the retail and service sectors, among other things. It represents approximately $1 trillion in business, represents 1/3 of the retail economy in this country. So it's a very huge business and an area of practice that is somewhat interesting and has some significant issues to it that affect all areas of your other practice, whether it's corporate, litigation, or real estate. First question that people ask me when I speak about franchising is, what is a franchise? A franchise is defined as having three elements. The first element is generally a trademark. That is, the franchisee operates under a trademark that is associated with the franchisor's business. You've seen McDonald's, you've seen many, many other companies that utilize trademarks that allow their franchisees to use those names in the operation of their business. The other two elements are a system or a method of marketing the business to franchisees so that franchisees can follow a marketing plan. The third issue, the third element, is a franchise fee, and that is generally a payment of royalties or an upfront franchise fee by the franchisee to the franchisor. That's the general definition. New York's definition is somewhat different, and I'll talk about that in a moment. There are other states that also define franchises as businesses that have a community of interest with their franchisees. Generally speaking, the business relationship is the same whether it's New York or in another state, but there are different definitions in different states. New York's definition, as I said, is different than other states in that New York only requires a trademark or a system and a fee. That is, it requires two of the three elements, and one of those elements has to be the franchise fee. It makes it unique among the 13 states that govern franchising directly, and the Federal Trade Commission, which governs it on a federal level. Franchisees must comply with the Federal Trade Commission regulations concerning the sale of franchises. If they're in New York, they have to comply with the New York State Franchise Sales Act, and they have to always have to provide, whether they're in New York or any place in the country, what's referred to as a franchise disclosure document, that's sometimes referred to as an FDD. Back a few years ago, the document was changed from what was referred to as a Uniform Franchise Offering Circular, or UFOC, and now it's called a Franchise Disclosure Document. So you may have heard of a UFOC in earlier practice, but these days the document that franchisors provide to their prospective franchisees is what's called an FDD, or Franchise Disclosure Document. As I said, there are 13 states, New York one of them, that regulates the sale of franchising. And that means, generally speaking, that the franchisor has to provide this disclosure document, this franchise disclosure document, to its prospective franchisees. 12 other states govern the sale of franchising in the same way, requiring the provision of an FDD and regulating the disclosure information that's provided to a franchisee generally. There are also 20 states in the United States that have what are referred to as relationship laws. New York is not among them, but they have what are referred to as relationship laws that govern the relationship between the franchisor and its franchisees subsequent to the acquisition by the franchisee of the franchise. And so those relationship laws govern termination. They govern the course of conduct and the course of business between the franchisor and the franchisee as the franchisee continues in business. But the New York focus and the Federal Trade Commission focus and the 12 states that require the provision of an FDD is the pre-sale disclosure requirement. Now, New York's law, the Franchise Act, is in Article 33 of the General Business Law. Section 681 is where it starts. The law was enacted in January 1981. It was one of the earlier laws enacted after the Federal Trade Commission enacted its regulation in 1971, and California, I believe, in 1979. New York was the next state to do it. It provides for pre-sale disclosure of a substantial amount of information about the franchise offering to the prospective franchisee, as I said, in the form of a franchise disclosure document. There are also civil and criminal penalties under the New York State statutory scheme, so that if the franchisor violates the disclosure requirements, there is liability both on a criminal level and on a civil level. And I'll talk about those types of claims, at least on the civil side, in a few moments. You should look carefully at the franchise disclosure law in New York to determine whether or not your client requires you to provide or requires the provision of a franchise disclosure document to its prospective franchisees. New York law is, as I said, very clear about the requirements, and if your client fits into that mold, they have to provide the information in the form of a franchise disclosure document. The registration requirements with New York State, that is, you have to file the New York State law. New York State law requires you to file a franchise disclosure document unless you meet some of the exemptions of the law. There are various exemptions that allow a franchise or not to disclose or not to provide a registration in New York State, but still required to provide franchise disclosure document to a prospective franchisee. So for example, a company like McDonald's I mentioned before, which has obviously millions and millions of dollars, if not billions of dollars in revenue from its franchise business and net worth of billions of dollars, is not required to file a disclosure document with New York State. Other companies which have over $15 million in assets are not required, or net worth are not required to file a franchise disclosure document with New York State. But if you're under that requirement, you must do it unless you meet one of the other exemptions. The exemptions are in Section 684 of the General Business Law. Now, the registration requirements are that the franchise disclosure document, which again I'll describe in much more detail in a few moments, must be registered with the State of New York. It's filed with the New York State Attorney General's office. It's reviewed by an examiner at the Attorney General's office and approved for filing. And only after it's approved and registered with the state can you sell franchises. Now, not only does it limit the ability to sell franchises until you're registered, but you're not allowed to offer the sale of a franchise. So franchisors are not allowed to speak with prospective franchisees unless they have registered and discussing the possible sale, to discuss a possible sale of a franchise, unless they've registered with New York State to sell franchises. And that means that you can't have a serious conversation about the possibility of selling a franchise to a prospective franchisee until you followed the regulations and registered your franchise. New York is unusual in another respect as well. New York regulates the sale of franchises to New York residents or from New York-based franchisors, and most states don't do that. So if you have a client who is a franchisor, a would-be franchisor in the state of New York, and he has a franchisee or prospective franchisee in, say, Connecticut or New Jersey, he's still required to register even though he's not selling a franchise in the state of New York. By the same token, a franchisor who is selling a franchise to a franchisee located in New York State is also required to register, since the franchisee is going to operate in the state of New York. This requirement is different than most states in that most states simply require the provision of an FDD if you're selling franchises to a franchisee in the state in which the franchisee will be located. And as I said, you have to register the franchise disclosure document in the state before you sell the franchise, and you have to provide the FDD to the franchisee before the franchisee is able to consider acquiring the franchise for you, or at least before you're entitled to have significant conversations with the franchisee rather, concerning the possible acquisition. Now, the franchise disclosure document is basically, as the title indicates, a disclosure document. The FDD and the former UFOC have had a substantial amount of information concerning the business deal that the franchisee is going to get into. There are 23 separate items of information that are provided in the FDD. And in addition to the disclosure documents, the disclosure information in the disclosure section of the FDD also includes a franchise agreement, financial statements of the franchisor, and other contracts that the franchisee is going to be required to sign, whether it be a non-competition agreement or a telephone assignment provision, which I'll talk about in a moment, or any other document or agreement that the franchisee has to sign either at the time that he acquires the franchise or at any later date. Generally speaking, the pre-sale disclosure involves information concerning the franchise business generally. What's the nature of the business? Are you going to sell hamburgers? Are you going to provide mail services? Or are you going to clean houses? Are you going to wash cars? Anything that describes what the franchisee is going to be doing and the background of the franchisor and how long they've been selling franchises. In addition to describing the franchise business, the the FDD describes the contract rights and indicates what the franchisor is going to do for the franchisee and what the franchisee is expected to do in operating the franchised business. It also describes all of the investment requirements of the franchise and recurring fees that are required to be paid by the franchisee to the franchisor. There is also substantial information about the background and experience of the management of the franchisor, as well as contact information. This is very important for your franchisee clients, contact information for current and former franchisees who the franchisee who wants, prospective franchisee should contact before acquiring a franchise. The franchise disclosure document, as I said, has to be registered with the state before the franchise is sold. It's good for a period of approximately 1 year. It has to be renewed every year with new financial statements within 90 days of the end of the rather with 120 days of the end of the fiscal year of the franchisor. So if a franchisor is on a calendar year, for example, the registration from 2010 will ran out on April 30th, 2011, and they have to renew a franchise registration before they're able to sell or offer for sale franchises in 2011. The franchise disclosure document is provided to the prospective franchisee at what's referred to as the first personal meeting of the franchisor with the franchisee, or at least 10 days or 14 days prior to the time that the franchisee signs a franchise agreement. The Federal Trade Commission regulations are somewhat different, and you have to meet both requirements. So it's well worth the time to review requirements in both the Federal Trade Commission regs as well as in the New York State regulations.